Welcome. Thank you for joining us on Season 4, Episode 5 of BNP Associates Community First podcast, where we discuss legal and social issues affecting the community. Today, we are joined by a gentleman who I like to refer to as BNP Associates Legal Associate of the Year. He has a background in land economy, Masters from University College of London in Environment, Sustainability and Development. He is a qualified lawyer and he's a professional member of the Ghana Institution of Surveyors, Valuation and Estates Division. And as I said earlier, best of all, he's a legal associate at BNP Associates. We're joined by Mr. Peter Kosi Simpson today. Welcome, Peter.
Thank you very much, Michelle, for your kind introduction and kind words. I'm happy to be here.
All right. So today you're going to help us to discuss a certain topic about land and the concept of interest in land. And as I introduced you, I'm sure our viewers have realized that you are the man for the job. And so we're going to go through certain things. And at the end of these topics that we discuss, our viewers should know the interest that they can hold in land, how they come to hold those interests, if there are any restrictions that apply to those interests.
Very well.
Okay. So, Peter, tell us, what really does it mean to own land in Ghana?
Okay. Before we go into the ownership, it will be good to understand what land itself means in law, and that will help us to understand the concept of ownership of land in legal terms.
Okay.
I will use two approaches to explain what land means in law. That's the invented pyramid principle, and also the legal maxim of quid plantater solo cedit.
Hey, these are big terms.
Oh yeah, no, it's not so big. It simply means whatever is attached to the land becomes part of the land. Now, the invented pyramid principle looks like a V, right? Which implies that the surface of the land itself, everything that is beneath the land to the center of the earth. Then everything that is above the land into the sky. So the concept of ownership in law, or the concept of land in law, means that the land itself, everything that is below the land into the center of the earth, and everything that is above into the sky, it belongs to the person who owns the surface of the land. Also, the second one being the quid principle, which means whatever that is attached to the land is also part of the land. So the land comprises everything that is attached to the land, either by nature or artificially. So we are talking about trees, water bodies, buildings on the land. So everything that is attached to the land is also part of the land, right? Which is subject to maybe the degree of annexation. That is the extent to which the thing is attached to it.
Okay.
Now, it also includes like rights and interests. And that is really what we are talking about when we discuss the concept of ownership of land in law. Yes.
Okay. So what I understand you to mean is that if I own, let's say, this space in front of us, anything I find under belongs to me. Anything on top of it attached to it also belongs to me. Now, what if I find gold under?
Okay. Well, this concept of ownership, although it seems like it is so broad and it covers everything, is subject to some restrictions.
Okay.
Although ordinarily you are supposed to own everything on top of the land and down to the center of the earth and everything above it, the law has certain provisions that restrict your ownership. For example, when it comes to Ghana, minerals in their raw state, on or in any land, they are vested in the state and vested in the president on behalf of the people of Ghana. So even though it is expressed that you own everything inside the land down to the center of the earth, when it comes to minerals in their raw states, these are vested in the president by law. So that's like some form of restriction on your ownership. Also, water bodies, same. These are also vested in the president for the benefit of the entire people of Ghana. Right. So the concept of ownership is limited by certain provisions. And as we go on, I will indicate some of these restrictions that the law provides against ownership of land in Ghana.
Okay. Now that you talk about the vesting of minerals and resources in the president, something that comes to mind is, for instance, and I know that the law is not too clear right now. If I'm pushing, it's a hot take here, but the thin line between ownership in land and this new thing that has come up, carbon credits.
Okay.
You know, if I have trees on my land and let's say it's able to give off oxygen, which accounts for some or feeds into some form of carbon credits. How do you manage those nuances? Who actually owns the rights? And it's just something that I'm putting out there. I don't know if you have any thoughts on it.
Well, yeah. Well, before you're able to maybe sell carbon credits, it must be from some form of green investment or green development, right?
Yeah.
So you may only be able to appropriate those credits if you show that I have invested in so and so green development, and this is the amount of carbon dioxide I'm able to take from the atmosphere, or the carbon sequestration that this my development has contributed. There's only then that you're able to, let me say, get some credits for that. For the development to even qualify to be traded, or the carbon credit qualify to be traded on the carbon market, it must meet certain criteria by law, which is like an intentional investment in carbon, how do you call it? Carbon projects, yes, to earn that credit. So naturally, although you may have trees on the land, you cannot just say, because I have so much trees naturally on the land, I'm coming to trade or sell like the carbon.
So there's no payment for no effort.
No efforts. No. You won't get payments for no efforts. Yeah.
All right. So let me take you back to our main topic, which is the concept of land ownership in Ghana. What are the categories of ownership of land in Ghana?
Okay. So broadly in Ghana, we have two categories, which are private lands and state lands.
Okay.
Now, private lands, they form majority of the land mass in Ghana. And these are lands that are owned by stools, families, clans, and individuals.
Okay.
Yeah. So they form about 80% of all the lands in Ghana, that is statistically. Then the other one being state lands. These are lands that are vested in the states, in the president, for and on behalf of the people of Ghana. And they were actually acquired through compulsory acquisition of private lands, and also vesting when it was legal to vest land in the state. Yeah.
Okay. And are all these registrable? Because I know Ghana has a very complicated system of registration. Are all these interests registrable?
Yes. This I would say that when it comes to like registration rights and interests, which we will drive in later, they're actually guided by both the customary legal system and the statutory legal system. So I would say that Ghana has like a plural legal system when it comes to land ownership, management, and transfer. And the statutes and our laws actually recognize these two varied systems, right? So we have acquisition through customary methods that are actually recognized under the law. For example, oral grants are recognized under the Land Act. And those type of grants are actually exempted from the formal validity requirement.
Okay.
Even when you look at the first schedule of the Land Act, it has a form by which you're able to record such oral grants that will help you to actually register it. Yes. But the registrable interests are also provided for under the Land Act. These are specific rights that you can own in the land, and that is what you actually own and not the land itself. It is the interest that defines your ownership, that determines how or what rights you're able to exercise in respect of the land. So ownership of land is actually, there's actually some form of misconception about it. People think I own the solid part. That is my land. I'm going to buy a land. No, what you acquire rather is an interest in land, right? And that is what you have. And that is what entitles you to do certain things or entitles you to the bundle of ownership rights that you may be able to exercise in respect
Depending on
of.
the interest that
Exactly.
you hold.
Exactly.
Okay, so can you give us, for those who are not lawyers, can you explain? I know you've spoken about interest. What exactly do you mean by interest?
Okay. So basically, I would say interest is like the bundle of rights,
Okay.
right? Different rights put together that defines a person's ownership to land. So it defines the extent of your ownership, the things you are able to do with the land or on the land.
Okay.
Right. So put together simply is a bundle of rights. What defines your ownership?
So, for instance, if I can also give the land to someone else,
Exactly.
or if I can farm on the land,
Right.
if I can build something on the land. So
Yes.
all those are the little things that come together to describe the interest I hold.
Yes. So holding an interest will entitle you to certain incidents, like things you can do, like what you'll be able to do with the land, the extent of what you can do. Right. So simply put, that's the interest. All
Okay.
the rights that you may be able to exercise put together.
Okay. So can you give us a crash course on the interest? I know Ghana's system is complicated.
Yeah, gladly.
Yes, but just in a few minutes, just run us through
Okay.
what the interests are.
So when you look at Section 1 of the Land Act, it lists the various forms of interest that one can own in the land.
Okay.
With the first one being the allodial title. And this is the most fundamental, the highest form of interest that one can own in land in Ghana. It's usually vested in like the land owning community, right? But exercised by the head or the headship of the land owning community. For example, when you take two lands, the allodial title is for like the whole of the community, the stool community, but it is vested and exercised by the occupant of the stool. When you take family land.
So in that case, the chiefs do not own it. It's just that it's vested in them.
Yes.
for the people of that community, right?
Yes. Legally, these heads of the various stools of families, they are just fiduciaries. They are trustees of the land. So they are just in a position to manage and control the land for the benefit of the entire land owning community.
Okay.
So it does not make them the personal owners of the land, right? Just that the allodial title is vested in them, and they are supposed to administer and manage it for the benefit of the entire land owning community, right? So, like I was saying, for family lands, it is vested in the family head. He doesn't own it, but personally, it's for the whole family. So he's supposed to manage it for the benefit of the entire family. Some levels of organization, there's also the clan, maybe different families put together called clan lands. And that is also vested in the clan head. Right? The state also owns the allodial title to the lands that was compulsorily acquired. And this is vested in the president and managed by the Lands Commission on behalf of the state. So that's like the first category of interest.
But in
that
all
we have in land.
these explanations you've given in terms of the stool, the clan, the family, I didn't hear individuals. Is it possible for an individual to hold allodial title?
Yes, it's possible for an individual to hold allodial title in times when the law did not prohibit outright sale of land. There was some individual who acquired land outrightly. And in this case, because they no longer owe any form of customary service or allegiance to like the original owners, it can be said that they have the allodial title to those lands. Right? What ties the other forms of interest to the allodial title is that you owe some form of customary service or allegiance to the head interest, which is the allodial title. And once that is not there, once that is severed, it means the allodial title becomes vested in an individual that outrightly owns the land and does not own any customary allegiance to the person or the family from which he acquired the land.
The land, okay.
Yeah.
All right. So what's the next type of interest?
So the next type, I'll talk about the freeholds. And the Land Act recognizes the customary law freehold and also the common law freehold. Now, the freehold interest, generally speaking, is like a perpetual interest in land. Like you own the land into perpetuity. Like you own it forever. And what differentiates the common law freehold from the customary law freehold is the system of law under which it is acquired. Like I was saying earlier, Ghana, the customary system is applicable. The statutory system is also applicable.
Yeah.
Right? So when your acquisition was under the customary law and what you acquired is a perpetual interest in land, then it means you have acquired a customary law freehold. The customary process may include maybe taking drinks to the chief, performing some form of appreciation rites, under our custom. Once you follow those processes in the acquisition, then what you get is a customary law freehold. Now,
even after acquisition,
Yes.
are there no certain duties that are imposed on you? Because I remember when I was in undergrad, a landlord teacher would say that if, for instance, there's a rule in the community that you're supposed to be cleaning up every Tuesday or Thursday, and you decide that you are not going to do it, that's good.
Yeah, that's true. So it ties back to what I was saying earlier about individuals owning the allodial title. In this case, what you acquired is just the freehold interest, and you still own certain customary allegiance and service to the allodial title holder. So if it is a stool land and you are supposed to perform certain customary services, yes, that is an obligation on the freeholder, customary law freeholder, or even common law freeholder to perform those services.
So under the common law, for the common law freeholder, who would the common law freeholder be performing those services to?
That's if you acquire it from the stool, then it is owed to the stool. If it is from a family and there's certain allegiances or services to be done, then it will be to the family, right? And if it is from the state, then it may not be customary services, but you owe certain obligations to the state, right? Now, these obligations are not proprietary in nature. Because the interest is perpetual, if you want to sell, you don't need the consent of anybody to sell. So they are not proprietary in nature, but they are jurisdictional and customary. Okay. Just like respecting the laws of the land, like you gave in your example. Like instead of the allodial title holder trying to determine how you use and manage your land, right? It's not subject to the consent of the allodial title holder. But these are just jurisdictional and not proprietary.
Okay. So I just want a bit of clarity again on the common law and the customary.
Yeah.
So customary, you get it from the stool?
Yeah. Either stool. Yeah, stool mainly.
Stool okay.
Mainly, yeah.
And then the common law, you get it from where?
Common law, you can get it from the stool's family, from the state. But it is the process of the acquisition that determines whether it is common law or customary. If the process is a customary process, taking drink to the chief, paying the right compensation, performing the appreciation or the guaha, depending on which area you are coming from, then it is a customary law freehold. But if it goes along the lines of an English transaction, right? Offer
an agreement.
The agreement, you enter into a contract, you are paying for the land, right? That is the common law freehold.
What if it's a mix of both? Because sometimes you would have the indenture and then, or the contract,
Yeah.
to put it conveyance, and you will still perform the customary rights. So how do you draw that distinction?
That's some of the problems of the legal system, where sometimes because of the overlap between the system, things are not like very clear cut. Yeah, but there are key incidences of that interest that makes you know that what I've acquired is the freehold. Now the distinction is just to help people understand that it doesn't matter whether you acquired it through the traditional process, right? Your interest is still valid and recognized under the law. So when you look at the registrable interest, the land law actually recognizes a customary law freehold as registrable. So the fact that how you acquire the land is by going to the chiefs and performing certain customary practices doesn't mean that you cannot go and register the land and have a valid title, right? Okay. The distinction is just there to tell you that it is recognized under the law, and you can regularize it and have a title certificate.
So if I'm a foreigner, can I have customary law freehold or common law freehold?
Like I mentioned earlier, there are some restrictions to the ownership rights, right? And one of the rights is your right to transfer the land. But the law is restricting you when it comes to transfer to persons who are not citizens of Ghana, right? The law states that persons who are not citizens of Ghana cannot hold a freehold interest in any land in Ghana, right? So it means that an allodial title holder is unable to carve such an interest to a person who is not Ghanaian.
Okay.
Right? Even when it comes to carving a freehold interest from stool lands and now family lands, the law has placed a restriction on that, stating specifically that there shall be no creation of a freehold interest in a stool land or in a family land.
Okay.
Right? Howsoever described. Once it looks like a perpetual interest that you are creating from a stool land or a family land, it is prohibited by law and you are unable to do that.
Okay. So what are the other interests that can be held?
Yes. So the next broad category is the usufructuary interest. Now, this interest is an inherent right of a member of the land owning community to an unoccupied portion of the communal land. For example, if the family or my family holds the allodial title to a vast portion of land, and I'm able to identify a portion of land that is not in the occupation of any member of that family, I have an inherent right to enter into that land, occupy that land, and use that land, right? And once I enter into that land and appropriate that land, I have a valid interest, which is a usufructuary interest. And it is recognized by law. I can also approach maybe the head of family and say, oh, I want this an occupied portion of the family land for my use. And the head of family or the stool, the occupant of the stool, will grant that to me, right? So this is just like an inherent right of a member of the land owning community to a portion of land that is not occupied. Now, the Land Act has also recognized that the usufructuary interest can be acquired by persons who are not indigenous of the land owning community through long possession for at least 50 years. But the possession must be known to the allodial title holders. So although originally I may not be a member of the land owning community, if they permit me to stay on the land for at least 50 years, I am acquiring the usufructuary interest and I become a usufruct, right? So the usufructuary interest is very, very interesting. So as a usufruct, I enjoy exclusive possession. And I even have a right to bring an action in trespass against the allodial title holder. So although it is family land, once I'm able to appropriate a portion to
In
myself.
the right way.
Yeah, in the right way, and I'm a usufruct of that portion. Even the family, other members of the family cannot now come in to lay claims to possession of that land. No, I have exclusive possession. I may be able to transfer it to other people's when I follow the proper structure or process. When I die, I may be able to, my children can inherit that interest.
So how is it different from customary freehold?
Yes. So customary law freehold, see that is you acquiring the land through a customary law process. The usufruct is limited to members of the land owning community or persons who are non-indigenous but are allowed to occupy the land for the long period of 50 years and over. Right.
Okay.
The customary interest is an inherent right. That is how the Act describes it. So by virtue of the fact that you are a member of the land owning community, you have certain right, or you have the right to enter into any unoccupied portion.
That's the usufruct.
Yes, the usufruct. You have that right. So once you exercise that right in respect of any unoccupied portion of the land, then it is validly acquired. So it's an inherent right, and it's not like it is created like the customary law freehold or the common law freehold.
So with the customary law freehold, you take active steps
Yes,
to claim
to
ownership.
acquire ownership.
Acquire
Yes.
ownership. With the usufruct, you just enter and possess your possessions.
Yes, that is one means, like usually because formerly the land was in abundance, you can do that. But now because of scarcity, like
You can't
have to
just
go
enter into
through-
anybody's land.
Exactly. Their families themselves may have an approach of you exercising that right.
Yeah.
Say if you want portion of the family land to use, come and see the head of family with certain things. So that's what we call an express grant. That's the family head will grant you like that the right to a portion of the land.
Okay.
So we have the implied grant, which is you identifying the land which is not occupied and just going to occupy, which is recognized by the law anyway. But now, because of how things are changing, scarcity, then you have to go by the established process. That is going to see the family head, talking to him that, I want part of the family land, maybe for farming or for building my residence. Then you acquire it from.
Then that
family
means that
head.
the express grant is beginning to look a bit like customary freehold.
Yes. But the difference is that, like I said, there's a prohibition of creation of freehold interest in any stool of family land. The difference is that in that case, it is not being created for you. You have an inherent right.
There.
Yeah. So it's just that maybe they are affecting your rights to that portion.
Okay.
So the express grant is just like a formal recognition of your usufructuary rights or interest to a certain unoccupied portion, and not creation of a freehold interest for you. Yeah.
That's an interesting one, right? And then what's the other? I've been hearing of leasehold. I have a lease. I know that's the most common type. And people in their minds feel like I have a lease and so it's forever. So can you shed some light on that?
Yeah, like you said, that's like now like the most common form of interest in land. Mainly maybe because of the prohibition of creation of freehold in the stool and family lands now. The leasehold is like a terminable interest in land. That is, the interest only exists for a specified period, right? Or a specific time, or a time period that is ascertainable.
Okay.
So, for example, the land is granted to you only for 50 years, right? So you only have exclusive possession or the ownership rights to that land for 50 years. After 50 years, the land reverts to the grantor, who may be like the usufruct or the freeholder or the allodial title holder. So any of the superior interest holders, the allodial title holder, the freeholder, or the usufruct, may create that right, the leasehold interest for a person for a specified time.
You know, in the past, there used to be a lot of 99 years, for the leases. But now I'm seeing a lot of 50-year leases. Is there a reason behind that?
Yeah. Like I mentioned, the lands in Ghana, they are usually communally owned, right? And granting a lease for 99 years, it feels forever, right? It's like you are denying the communal or the members of the land ownership access to that land for so long a time. Okay. And it actually defeats the policy reasoning behind the non-creation of freehold interest in this communal lands, right? I will say that one of the customary or the social notions of land in Ghana is that it doesn't belong to just the people who are alive now. It belongs to people who had already died and persons who are not born yet, right? So this is what our laws are seeking to protect: intergenerational equity, because it belongs to all of us. And we have to protect communal lands for even generations that are not yet born.
Even with the new pricing or the new leases given around 50 years, sometimes when you're even buying, it's up to 20 years left on the lease because the original grantor, whoever has given it to you, got it for 50 years.
Right.
So aren't you being, doesn't that conflict with real estate being an investment, a long-term investment, especially if you're buying it for generations to come? Because real estate appreciates. Let's say I buy an apartment in one of these important developers' properties. And within that, let's say they sublet to me and I have just 20 years. I've bought land for maybe $125,000 in a location that I think is very prime. And then in 20 years, I have to renegotiate. I could be priced out of the market.
Yeah.
What does that mean for me?
These are real concerns.
Yeah.
That's why once you are going into any form of land investment or investment in lands, you have to ascertain the interest that you are acquiring. If it's a lease, which is now like the most common form of interest that you can get on the market, you have to determine the unexpired term or what is actually being granted to you for you to ascertain whether it is worth it, looking at the term of the lease and the investment or the money you have to invest. There are options or the ways out for you to renegotiate an extension or a renewal of the lease. You may want to protect yourself by putting in some guidance in the original agreement to guide the pricing. Yes, but it doesn't really work. The other option is that you have to abandon it.
After paying so much,
yes,
thinking that you are investing, then you have it for 20 years, and then they tell you the next 20 years, they tell you that, okay, come and pay $1 million.
Yes. So if you don't have terms in the original contract that will guide the pricing or the negotiation of the terms, and you want to leave it to the market, it may go as high as that. And like I said, even if it's a bare land that you bought and you now come and put a huge building on it and the lease term is just 20 years, after that 20 years, you have to forgo everything. Because remember the definition, whatever is attached to the land becomes part of the land.
So
everything reverts to the grantor, the original grantor who has the reversionary rights.
Yes. Now, another worrying, I think I've come across some worrying incidents of developers putting in terms or clauses that say that your renewal is subject to my discretion and how you functioned as a tenant. Let's say I have an apartment and they have all these service fees and things which they don't want you to question. Now, if I object once or twice and say that, oh, you didn't live up to what you were supposed to do, then that becomes a bargaining chip for the developer to say that 20 years is up. You better, pay 1 billion or you're out,
Yeah. Well, the thing about it is that most of these parts of land transaction, they are subject to contract. They are subject to agreements. There are some covenants or that run with the land. Yeah. Even sometimes the law recognizes this one. And the law recognizes them as implied terms, even if you don't contractually agree on it. The law is implying those terms, and those may be able to help you. For example, there are now some form of renewal clauses like that are implied by law under certain conditions. For example, if you are a member of the land owning community and you lease land and it expires, the law says you're entitled to an automatic renewal.
Yeah.
If you are a Ghanaian, the law says there is an implied term of renewal. So although it's not automatic, it means you have to renegotiate the terms, right? So right from the beginning, you need to know what you are acquiring, and you need to know what contractual terms to put in those leases to guide the renewal renegotiations or the extension negotiations, right? That is why this discussion is very important for you to
Very
know the
worrying.
interest in land, what you are acquiring, what you have to do to safeguard your interest and your investment.
Yeah.
Yes.
Okay.
So
So the
there's a
next,
final one.
yes.
Yes. They are the customary tenancies, right? And these are by contract, by agreement. You can enter into an agreement with the allodial title holder, the usufruct, the customary law freeholder to use certain portions of the land for long. So these are just like agreements to use the land. And these interests are recognized in law. Now, the constitution can be the payment of rent, but if it is an agricultural setting, then it can be like the sharecropping arrangement that we know, the Ebunu and Ebusa. Like those are how the
But are
forms
those
that
still actively explored nowadays?
yes. When you go to some of the farming communities, they're actively
Okay.
explored. And the good thing about it now is that these are registrable interest in land now. So all this like a sharecropping arrangement. You're
can
able to go to the
register.
Lands Commission and register your interest that I have a Bunu interest in this land. Yes.
So that leads me to a question. I know that there are some registrable districts in Ghana and there are some non-registrable districts. Can you shed a bit of light in a few
Okay.
seconds?
So when it comes to registration of land, let me use that loosely. There are two regimes. We have title registration and deed registration. Now, title registration registers ownership and proprietorship in the land.
So for instance, the Buno and Ebusa,
Yes.
the interest that you have, or at
Yes.
least hold interest.
Yes.
Okay.
So it registers your ownership. It registers the interest itself in land and gives you a land certificate indicating that you have this interest in this land, or you are the proprietor of this land for this interest.
Okay.
Okay. Now, this title registration is only in Accra and certain parts of Kumasi. Now, they are the districts that have been declared registrable districts. Now, the other parts of Ghana only have the deed registration, and these system only records transactions that are affecting land, right? So if I enter into any transaction, I'm able to take it to the Lands Commission to record that transaction. So that only has a track record of the transactions that are in respect of a certain portion of land, but does not register the interest that the transaction seeks to give. So you don't have a land certificate declaring you as the owner or a proprietor of certain interests when you do a deed registration, but you have an indication that your transaction has been registered as affecting that portion of the land.
So
Yes.
essentially, it's like you saying that, or the Lands Commission saying that, oh, I know that something has gone on this land,
Yeah.
but
Yeah.
as to whether it's valid, it's almost like plotting.
Yeah.
It's almost like plotting under the title.
Yeah, but it is also still helpful because as a new person or a person who wants to purchase a land, at least when you go and do your search, you have some indication that, oh, certain things have gone on, right? So you have to deepen your investigation on those lines to see what actually went on, right? Which will indicate to you who now has the interest to grant you the land or sell the land to you.
So that makes investigating or doing your due diligence in um, document registration districts a bit more difficult than title, right?
Yeah,
To
it
an
makes it.
extent.
Yeah, it makes to an extent. It makes it more difficult because you don't have a clear indication that so and so person has title to this land. You only know that this land is affected by this number of transactions. There may be other transactions that are not recorded, but the law offers some protection. For example, priority of the registration that will help you legally,
Yeah.
to be able to assert certain rights. But I mean, it gives you a fair idea of who you have to speak to, who you have to acquire the land from, what previous transactions were recorded in respect of the land, and it guides your acquisition process.
Okay, so we're going to do something different right now.
Okay.
I'm going to call it a fireball session.
All right.
What we're going to do is we're going to talk about when I mention the type of interest that you've described, then you tell me how I can get it.
Okay.
2 words or 1 word.
Okay.
Okay. Allodial title.
Well, now getting an allodial title.
This is a fireball session.
No, for the
Don't
allodial
answer like a
title.
lawyer.
No, for allodial title, it's not straightforward.
Okay.
Maybe now compulsory acquisition.
Okay.
That's the state compulsorily acquiring the land. I think that's the only viable way now, or maybe a gift to a stool, right? Maybe one land-owning community is giving a land to another land-owning community,
Okay.
right?
But you can't have like let's say a family that owns allodial title divesting itself.
No, because there's the prohibition that you can no longer create freeholds.
Is that really a creation? Is it not?
Well,
not a creation of free. I'm not talking about freehold. Though.
Yeah.
There's two. Let's say there's two divesting itself and saying that I'm giving this land to Mr. Peter Kosi Simpson.
That's why I mentioned.
Allodial.
That's why I mentioned gifts. But that is all. Also, it doesn't say just freeholds or howsoever described. So if within the law, I mean, what you are divesting yourself of can be likened to a freehold.
No, not freehold. Like allodial itself.
Yeah.
Proper.
Yeah, but if you look at the incidents, there is like the utmost or the highest form of interest in land. It has similar incidents as the freehold. So when you bring in that term, howsoever described, then there could be stretches that prevent the family or the stool from divesting itself. Yeah.
Okay.
So the most viable, or I may say the only viable means is the state using its power of eminent domain to compulsorily acquire the land from the stool or the family.
Okay, back to our fireball session.
Okay.
Customary law freehold.
Purchase, gift, inheritance.
Common law freehold.
Purchase, gift, inheritance.
Okay, usufruct.
Down to purchase, gift, inheritance.
But I thought you said usufruct, there's implied grant and then express.
Yes, because now the implied is kind of like, I don't know if you can still do that now. I mean, members of the land-owning community, maybe this is Nungwa's two land. As someone from Nungwa area, I cannot just go in and no. Even the chiefs will
Go and possess your possessions.
Yeah, because of the management issues, the misconception about management, chiefs acting like they personally own the land instead of just performing their fiduciary roles. I mean, this raises practical issues about the rights that indigents or members of land community can exercise. Even though the law recognizes that as a usufruct, you are able to go in and occupy an unoccupied portion. And do we even have any land that are unoccupied now? So
no, you'll be surprised. The hinterlands.
Oh, okay,
you may find some.
Yeah.
But you can't really say it's unoccupied because they kind of know.
Exactly. Maybe I've done something there some few years ago.
It's when you start putting your blocks on the floor that you will see the owner appearing.
Yeah.
Okay, leasehold interest.
A purchase, gift, inheritance. That one too.
Customary tenancy.
That one, like I said, is by contract. So I say purchase. Then gift. Because I said customary tenant, I may be able to divert my sale of the tenancy to someone else, my children can also inherit the tenancy.
Okay,
So,
but it means that they also have to do the farming that you were doing.
yes,
right?
of course. They have to, because by agreement, so they have to continue
What
with the
your terms are.
agreement and also with the consent of the landlord.
Okay.
In that
All
case.
right. Thank you so much, Peter,
Yeah.
for joining us. I have learned a thing or two, and I believe that our viewers have also learned a thing or two. We're open to continuing this discussion. So if you have any further questions, we have our in-house experts. You can reach out to us at info@bpaghana.com, and you will be happy, more than happy, to address your questions. It's been lovely having you in our studios, and we look forward to having you again on the next episode. Thank you, Peter, for honoring us,
You're welcome.
and have a lovely day.